Welcome to the Deep Dive. This is where we take source material, really dig in, and pull out the key insights for you.
Exactly. We're here to get you informed quickly without you having to wade through everything yourself.
And we're continuing our journey through the Manual of Patent Examining Procedure, the MPP.
Yeah.
It's the essential guide for patent prosecution.
It really is. And today we're in Chapter 700, which covers the examination of applications.
Specifically, we're diving into MPP Section 713, the topic, interviews.
Right. And these aren't your typical interviews. In the patent context, an interview is a formal, well, sometimes informal, but still documented interaction.
Between who?
Between the patent examiner and the applicant, or usually the applicant's representative, like your patent attorney or agent.
Okay, so it's part of that back and forth during examination.
Precisely. It happens during the prosecution phase.
So our goal today is to unpack what the MPP actually says about these interviews. Why have them? How are they done? What are the rules? Okay, let's dig in. So first off, how does the MPP define an interview? What's its purpose according to the text?
Well, the MPP frames it as a pretty useful tool. It says interviews are for clarifying issues, promoting mutual understanding, and advancing prosecution toward allowance.
So basically talking things through to move the application forward.
Yeah, that's the idea, to potentially clear up misunderstandings that might be trickier in, just written responses.
Makes sense.
And the text stresses they should be handled with professionalism and efficiency. It recognizes that both the examiner and the applicant or their rep are busy people.
Okay, practical considerations. How do these actually happen, like format and location?
The MPP is pretty flexible here. Interviews can be in person, by telephone, or via video conference.
So remote options are definitely included.
Oh, absolutely. They can take place on USPTO premises or remotely. It often depends on the examiner's work situation and what the applicant prefers or requests.
Interesting. So lots of ways to connect.
Yes, and here's a really critical point from Section 713.01. No matter the format, phone, video, in person, any substantive conversation is considered an interview.
Substantive. What does that mean practically?
It means if you're discussing the merits of the invention, the claims, the prior art, amendments, anything beyond just, say, scheduling or checking status, it counts.
Got it. So even a quick call could trigger the interview rules if you get into the details.
Exactly. It's the content that matters, not whether you formally called it an interview.
Okay, that's important. Now, what about when these can happen? Patent prosecution has distinct stages. Are there rules about timing?
Yes, definitely. The MPP lays out some guidelines.
Like when are they generally okay and when are they usually off limits?
So the general rule is interviews are not held before first office action.
Ah, so you wait for the examiner's initial written feedback first.
Right. The examiner needs to do their search, analyze the claims, and put their position in writing before a detailed discussion usually makes sense.
But are there exceptions?
Yes, a couple. For instance, in continuing or substitute applications where there's prior history, or if both sides agree, an early discussion would expedite examination. But typically, you wait for that first action.
Okay. What happens later? Say after you've received a final rejection, things seem pretty stuck then.
Good question. The MPP actually permits one interview after a final rejection.
Oh, really? Even after a final?
Yes, but with a condition. It's only allowed if the interview might place the application in condition for allowance or prepare it for appeal.
So it has to have a productive purpose, either to fix things for allowance or clarify issues for an appeal, not just to argue again.
Exactly. It's goal-oriented at that stage.
And what about the end game, after a notice of allowance issues?
Generally, no. Interviews are not allowed after a notice of allowance. The examination is basically done. Unless there are extraordinary circumstances, which you'd imagine are quite rare.
Okay, so clear windows. Now, who gets to actually have this conversation with the examiner? Can the inventor just call up?
No. The MPP is very clear on this. Interviews are only granted to authorized representatives.
And who qualifies as authorized?
Typically, this means registered patent practitioners, attorneys, or agents admitted to practice before the USPTO, or someone who holds a specific power of attorney for that particular application.
So just knowing about the invention isn't enough.
Definitely not. The text explicitly says, a mere power to inspect does not entitle someone to interview the examiner. You need the authority to act on the applicant's behalf in the prosecution.
That makes sense. It protects the process.
It does. And there are related rules about how that power of attorney needs to be established, especially for things like continuing applications or if an assignee who isn't the inventor wants their representative involved. It all has to be properly documented.
Right. It ensures the examiner is talking to someone with the legal standing to discuss the case substantively.
Precisely.
So let's say you are the authorized representative. How do you actually set up an interview? What's the recommended procedure?
The MB encourages using the official systems. Applicants should use the automated interview request, AR form, or the paper equivalent, the PTOL 413A form.
Why those forms?
Because they help structure the request. You're supposed to outline the issues to be covered. This gives the examiner a heads up so they can prepare, making the interview more efficient.
Preparation is key. What about just, dropping by or calling without scheduling, the walk-in approach?
The MPP specifically says examiners can decline unscheduled or walk-in interviews.
They can just say no.
Yes, especially if it's a complex case. They need time to review the file and the points the applicant wants to discuss. You can't just ambush them.
Okay, so schedule it properly. What if the interview is successful? Say you reach an agreement with the examiner.
If the interview leads to agreement on allowable subject matter, the expectation is clear. The MPP says applicants are expected to submit a prompt amendment to reflect that agreement.
So the conversation needs to translate into a formal change in the application file.
Yes, promptly. The interview itself doesn't change the claims, the subsequent amendment does.
Now, you mentioned earlier that any substantive conversation counts. This brings up something the MPP seems to really hammer home: record keeping.
Absolutely critical. This is probably one of the most important takeaways from Section 713.
Why so much emphasis?
Because, as we said, substantive discussions count. And the rule is that any such interview must be made of record in the file. Section 713.04 demands a complete and accurate summary.
How is this summary usually handled? Is there a specific form?
Yes. The interview summary form, PTOL 413-413B, is the standard.
And what needs to be in it? Just, we talked.
Oh no, much more detail. It should capture things like the claims discussed, any prior art referenced, specific amendments proposed during the talk, and the general thrust of each party's arguments. Enough detail so someone reading the file later understands what happened.
Who's responsible for creating this record?
It's actually a shared responsibility. The MPP states both applicant and examiner share responsibility for ensuring that the record is complete and correct.
So the examiner makes notes too?
Yes. The examiner prepares their own summary, usually on their version of the PTOL 413 form. But often, the applicant is asked to provide their written summary of agreements reached or points made, which then becomes part of the official record after the examiner reviews it.
What if the applicant is supposed to provide a summary, but they don't, or it's not accurate?
There are consequences. If an applicant fails to submit an accurate summary when required, the USPTO can set a deadline, typically 2 months, to fix it.
And if they miss that deadline?
The application could be held abandoned. It underscores how seriously they take this record keeping.
Wow, okay. So getting that summary right is crucial.
Definitely. And this applies to video interviews, too. There are specific rules there.
Like what?
The applicant needs to give authorization, either written or oral, for the video call. The USPTO uses its own official collaboration tools for security.
So you can't just use any video platform?
Correct. The MPP specifies the examiner must initiate or host the session using USPTO-approved platforms. It ensures consistency and proper record capability.
This focus on the record.
Mm-hmm.
It feels like it connects to broader legal principles.
It absolutely does. It ties directly into the duty of candor and good faith that everyone involved in patent prosecution owes to the USPTO. Having a clear record helps show that duty was met.
And what happens to these summaries?
That's the fascinating part. They become part of the official application file wrapper, the prosecution history. If the patent ever issues and ends up in litigation, those interview summaries are public documents.
So anyone can see what was discussed, what arguments were made, what agreements were reached years later.
Precisely. It makes those direct conversations part of the permanent formal record. It highlights why accuracy and completeness are so important.
Let's make this concrete. Can we use the example mentioned in the text?
Sure. Imagine an applicant thinks their invention, as claimed, is clearly different from 3 prior art references the examiner cited in a rejection.
Okay. They disagree with the examiner's interpretation.
Right. Instead of just writing another argument, they might request an interview.
Why? What's the advantage?
They can directly explain their reasoning to the examiner, maybe walk through the claim language side by side with the references on screen share. It could clarify misunderstandings that cannot be easily resolved in writing.
So a more dynamic explanation.
Exactly. Sometimes that direct dialogue is much more effective.
But there's a catch, right? What if they still don't agree after the interview?
Yes, the important limitation. The MPP notes that if the interview ends in disagreement, the necessity of a formal response to the office action remains.
So the interview doesn't replace the written response if you don't solve the problem.
Correct. It's a tool to aid prosecution, potentially leading to resolution. But if issues remain unresolved after the talk, you still need to file that formal written response addressing the outstanding rejection.
Okay, that makes sense. It supplements, but doesn't necessarily replace the formal written record unless agreement is reached and formally documented.
You got it.
So, wrapping up our deep dive on MPP 713, interviews are this structured yet potentially flexible way for examiners and applicants to communicate directly.
Right. They aim to clarify things, foster understanding, maybe speed things up.
But they come with very clear guardrails,
Yeah.
rules on who can be there, when they can happen, how to set them up.
And crucially, that requirement for thorough record-keeping of any substantive discussion. Making sure the interview summary is accurate and complete is paramount.
Understanding these rules helps make interviews actually productive and ensures the official file accurately shows what happened.
And connecting it to the bigger picture, it just highlights how vital, clear, well-documented communication is within the whole formal patent system. Everything needs to be on the record.
We want to extend a special thank you to Mike Shepard, the creative director who organized this entire audio series. And now for the disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and Notebook LM, and may contain errors or omissions. It is provided for general educational and informational purposes only and is not legal advice or a substitute for formal instruction. For authoritative guidance, consult the official MPEP, a qualified instructor, or a registered patent practitioner.
So here's something to think about. Knowing that every substantive discussion during an interview, even proposed amendments or arguments, becomes part of the permanent public record. How might that change the way you prepare for or what you choose to discuss in an interview during patent examination?